You know that feeling, right? It is almost muscle memory at this point.
Oh, yeah.
You download a new app, or you are standing at the reception desk at a clinic, or maybe just, I don't know, signing up for a loyalty card at a local coffee shop.
Right.
And there is a form or a pop-up box. And it just has thousands of words of this tiny microscopic text.
The dreaded terms and conditions.
Exactly. The wall of text. And what do we actually do? We definitely don't read it.
No one reads it.
No, we just scroll to the bottom, check the box that says, I agree, and we essentially hand over our life story.
Yep.
Name, email, phone number, maybe even a fingerprint. We trade our privacy for access, usually without a second thought about where that information is actually going.
It is the universal digital ritual. We want the convenience right then and there, so we just pay with our data.
We do.
But the reality is, once that data leaves your hands, I think most people have that sinking feeling of, who is actually looking at this? Is it safe?
Right. But here's the thing, and this is why we are here today. You aren't actually powerless in that exchange.
No, you're not.
There is a machine operating in the background, a massive legal framework designed to govern exactly that specific moment.
That is correct.
Yeah.
It is not the Wild West out there, even if it feels like it sometimes.
So welcome back to the show, everyone. This is the WeCyberYou Unlocked podcast. That is WeCyberYou Unlocked.
Glad to be back.
And today we are doing a deep dive into a piece of legislation that is honestly fascinating once you peel back all the dense legalese. We are talking about the Philippine Data Privacy Act of 2012.
Officially known as Republic Act number 10173.
Okay, let's unpack this, because I know Republic Act number 101173 sounds a bit
Dry.
Yeah, a bit dry. It sounds like something you would read to help you fall asleep. But looking at the source material we have today, this isn't just dry legal text. This is basically the rule book for the digital age in the Philippines.
It really is. And the whole mission of this deep dive is to understand the central tension that this law is trying to resolve.
Which is what exactly?
Well, think about the modern world. We live in an economy that absolutely requires the free flow of information. Business, government, communication, it all runs on data moving incredibly fast.
Right. If I can't send my data to the bank instantly, I can't even buy my morning coffee.
Exactly. But on the other hand, we have this critical, fundamental need to protect individual privacy. The law actually calls it the right to privacy.
Okay.
So RA 10173 is the fulcrum. It is the balancing act between keeping the economy moving and keeping your secrets safe.
So what does this actually mean for the average person, or even for a business owner listening right now? Is this just about stopping hackers, or is it, bigger than that?
It is much bigger. It is fundamentally about accountability. It's about lawful processing, ensuring that when you hand over your name or your address or your Face ID, you aren't just throwing it into a black hole.
I love that. All right, let's dive into Section 1 here, the scope and the goal. What exactly is this thing, and who does it actually apply to?
So this is where most people get tripped up. The assumption is usually, this is a law for the massive tech giants, the huge social media platforms.
Right, the big guys in Silicon Valley.
Yes. And while it certainly applies to them if they're processing data in or from the Philippines, the scope is way wider than that.
How wide?
The Philippine Data Privacy Act regulates the collection, processing, storage, and sharing of personal data by any entity.
Any entity at all.
Any entity. And here is the key detail that really stands out in the text. It applies to both private and public organizations.
Oh, wow. Okay, hold on. So not just the online retailer where I buy my shoes, but also
The government.
the government agency issuing my driver's license.
Absolutely. The government is not exempt here. If a government agency handles personal information, which they do constantly, they are on the hook just as much as a private corporation.
That's huge.
Whether it is the public sector or the private sector, if you handle personal info, you have to follow these rules.
That feels like a really important distinction. Because a lot of times you see regulations where the state carves out a nice little exemption for itself, sort of a do as I say, not as I do situation.
Not in this case. The law levels the playing field completely. It creates a comprehensive umbrella. And if you look at the core objectives in the source material, they really reflect that.
What are those main objectives?
Well, first and foremost, obviously, is protecting the individual's right to privacy. That is the North Star of the whole legislation.
Right, acting as the shield.
Second, it is to ensure organizations handle data lawfully, fairly, and securely. Those three words matter a lot.
Break that down for me.
It is not enough to just be secure. You could have the best firewall in the absolute world, but if you are using the data unfairly, you are still violating the law.
What does fairly mean in a legal sense here?
It means no trickery. You can't collect data for one reason, say a local raffle, and then use it for something completely different, like selling it to an insurance company without the person knowing. That would be unfair.
Got it. No bait and switch.
Exactly.
And the third objective?
Promoting accountability.
Accountability. That is a heavy word in tech.
It really is. It means you can't just say, oops, when something goes wrong. You are fundamentally responsible for the data you possess. You cannot outsource the blame.
So if you are listening to this and you are in the Philippines, or maybe your data is just being processed there, this is your shield. This is the thing standing between your personal life and total exposure.
That is a great way to put it.
But what are we actually shielding? Let's move to Section 2. The law talks a lot about personal data. Now, to me, personal data is my name, maybe my phone number. But in the digital age, the definition has to be broader than that, doesn't it?
Much broader.
Yeah.
And the Act is very clear about this. The basic definition is standard. It is any information that can identify a person.
Okay, so the classics. Names, addresses, phone numbers, email addresses.
Right. But then it expands into the physical and the digital. It includes government-issued IDs, which makes perfect sense. But it also includes things like photos, videos, and biometric data.
Biometrics. So like my fingerprint to unlock my phone. Or a facial scan.
Yes. That is personal data. It identifies you uniquely.
That's wild to think about. A photo of my face is treated with the same legal weight as my home address in this context.
Because it identifies you. In fact, facial recognition makes your face even more identifying than an address in some ways. But what is truly fascinating here is that the law goes even further into the modern digital landscape. It explicitly covers online identifiers.
Like what?
Like your IP address or your location data.
Wait, really? My IP address? I feel like I leave that behind everywhere I go online. It's like digital footprints.
You do leave it behind, but think about what an IP address actually represents. If I have your IP address and a timestamp, I can often trace it back to a specific household or a specific device.
Wow.
If I combine that with location data, I can place you at a specific spot at a specific time.
That is actually kind of scary when you think about how easily that stuff is collected by basically every website.
It allows for triangulation. If I have those data points, I can reasonably ascertain your identity. Therefore, under the law, it is protected personal data.
That is a massive coverage area.
And it gets deeper. The law creates a sort of extra protection tier for what it calls sensitive personal information.
Sensitive meaning more dangerous if it leaks.
Essentially, yes.
Yeah.
This category requires stricter security and much stricter rules for processing. It includes things like health information, genetic data, sexual life, religious or political affiliations.
Which makes total sense. You definitely do not want your medical records or your voting history just floating around out there. That is the stuff that can be used to discriminate against you.
Spot on. But it also includes biometric data in this high security tier.
Interesting. So health, finance, and fingerprints. Why are fingerprints grouped up there with medical records?
It connects back to the permanence of it. Think about it this way. If your password gets stolen, what do?
I change it. I mean, it is annoying. I have to think of a new special symbol and a number, but I just change it.
Right. You change your password. You can even change your name or move to a new address. But you cannot change your fingerprint. You cannot change your retina.
Oh, I see.
If that biometric data is compromised, it's compromised forever. You are vulnerable for life. So the law demands extra protection for it.
That makes the biometric part feel much heavier. It is not just cool tech to unlock your phone. It is highly sensitive data.
Exactly.
Okay, so we know who is covered, and we know what data is protected. Now let's talk about the you in WeCyberYou, unlocked. What about the listener? What rights do I actually have under this law?
This is Section 3, the rights of the individual. And this is really where the law shifts from just being a set of rules for companies to being a tool for empowerment for people.
Empowerment. I like that. Because usually we just feel like the product. We feel totally passive in this whole exchange.
RA 10173 wants to make you an active participant. First and foremost, you have the right to be informed. You have the right to know how your data is being used. They can't just take it and do mysterious things with it in the background. You have to be in the loop. It demands transparency.
So no secret algorithms deciding my fate based on data I didn't even know they have.
That is the goal. Then you have the right to access and the right to correct.
Break those two down for me.
Access means you can literally ask to see the data they have on you. You can knock on the digital door and say, show me the file.
Show me the receipts.
Exactly. Show me the receipts. And The right to correct is incredibly practical. Let's say a bank or a credit bureau has an error in your file. Maybe they have an old address, or they say you missed a payment that you actually made.
That can completely ruin your credit score.
It can. But under this law, you have the legal right to have that fixed. If you can prove it is wrong, they must correct it. They cannot just ignore your emails.
That is actually super practical. I feel like everyone has had a total nightmare trying to update an address or fix a typo with a utility company. Knowing you have a legal right to correct it changes the entire dynamic of that phone call.
It does change the dynamic.
Yeah.
But there is one right that I think is particularly powerful, and honestly, it's often overlooked. The right to object.
The right to object, that sounds forceful, like being in a courtroom. I object.
It is forceful. It means you can say no to certain types of data processing. You can outright refuse.
When can I actually use that?
A great example is direct marketing. You know those endless promotional emails or the spam calls you get?
The absolute bane of my existence.
You can invoke your right to object.
Yeah.
You can tell them, stop using my data for this purpose. And legally, they have to stop. You aren't just a passive source of data. You are an active participant who can withdraw consent.
That really feels like taking the power back. It is not just take it or leave it. It is actually, no, you cannot do that specific thing.
And if any of these rights are violated, you have the right to file complaints.
So there is real recourse.
There is. If your privacy rights are stepped on, you can go to the authorities. These rights create a framework for trust. It tells the user, you are not helpless here.
I love that. It turns the user from a victim into a claimant. But rights are really only half the equation, right? If I have rights, someone else has responsibilities.
That brings us to Section 4, Obligations of Organizations, or, as we might call it, the rules of the road.
The burden of responsibility. What do these companies and government agencies actually have to do?
It starts with purpose. The source text says data must be collected for specific, legitimate purposes.
So they can't just collect absolutely everything just in case they might need it 5 years from now.
No, that is called data hoarding, and it is generally frowned upon by this law. You need specific reason. Why do you need my mother's maiden name to sell me a pair of socks online?
Right.
If there isn't a legitimate purpose, you shouldn't ask for it.
And I assume they need to ask nicely.
They generally must obtain consent, and that consent needs to be explicit and specific.
Now, let's talk about safety. Because I can give consent, but if they just store my data on a laptop that some employee leaves on a park bench.
That is where the law gets technical. Organizations must implement reasonable and appropriate security measures.
That sounds a bit vague, to be honest. Reasonable and appropriate.
It is legal language, but it implies a sliding scale. The security for a local bakery's newsletter list might be very different than the security for a massive hospital database.
Yeah.
But you must have measures in place. It is not just about writing a policy, it's about technical execution. You have to actually secure the data.
You can't just say, we care about privacy in your PR statement and then leave the server password on a sticky note.
That would definitely not be considered reasonable or appropriate.
Yeah.
And to ensure this actually happens in practice, the law requires organizations to appoint a DPO.
A DPO?
A data protection officer.
Okay. So a specific person whose actual job it is to worry about this stuff.
Yes. This ensures that someone is actually responsible. It is not just the IT department's problem or legal's problem. There's a designated individual accountable for data privacy compliance.
That is smart, because if everyone is responsible, then no one is actually responsible. Putting a name to it helps.
And if they fail, if the security measures fail and there's a massive hack, they have an absolute obligation to report notifiable data breaches.
So they can't just hide it.
They cannot just sweep it under the rug. If a breach happens that puts people at risk, meaning sensitive data was exposed, they have to tell the authorities and the affected individuals.
That is huge. That explains why we suddenly get all those "we regret to inform you" emails from companies.
Yes. Before laws like this, companies would often hide breaches just to save face and protect their stock price. Now, hiding the breach is often a bigger violation than the breach itself.
And who is watching over all of this? Who is the referee blowing the whistle?
The source mentions the National Privacy Commission, or NPC. They are the enforcement body that oversees compliance and handles those complaints we mentioned earlier.
Okay, so we have the rights, we have the rules, and we have the referee. But let's be real for a second. Sometimes companies cut corners. What if an organization just completely ignores it? What if they play fast and loose with my biometric data to save a few bucks on server costs?
Then we get to Section 5, Consequences and Penalties. And let me tell you, RA 10173 has teeth.
I like teeth when it comes to protecting my info. What are we talking about here? A slap on the wrist, a sternly worded letter from the commission.
Far from it. The stakes are incredibly high. First, there are financial penalties, significant fines.
Okay, hits him in the wallet. That is standard corporate stuff.
But then there is imprisonment.
Wait, real jail time?
Yes. People can actually go to jail for violating this act.
That is a shocker. Usually with corporate compliance, you just think, oh, they'll pay a settlement, admit no wrongdoing, and everyone goes home. But jail.
It changes the calculus completely in the boardroom. Depending on the offense, whether it was unauthorized processing, malicious disclosure, or just gross negligence, we are talking about prison sentences that can range from 1 year up to several years.
That puts a real fear factor into it.
It does. It signals that the Philippines takes data privacy incredibly seriously. It is not just a standard cost of doing business. It is a criminal matter.
And on top of fines and imprisonment, there is civil liability too, right?
Yes, you can be sued for damages by the people affected.
Yeah.
And frankly, the reputational damage might be the worst part for a business.
Right. Because if you have to publicly announce a breach and you get fined and your officers are literally facing jail time, your customers are not going to trust you ever again.
Trust is the absolute currency of the digital economy. If you lose that, you lose everything. So the penalties are designed to be a very strong deterrent.
So let's zoom out for a second. We have covered a lot of ground in this deep dive.
Yeah.
We've got this law, RA 10173. It defines personal data broadly, from your name to your IP address to your actual face. It applies to everyone, government, and private companies alike.
And it gives individuals powerful rights to access, to correct, to object.
And it forces organizations to be fully accountable. They need a DPO, they need real security, and if they mess up, they face fines or even jail time.
It is a complete, holistic ecosystem of protection.
So what does this all mean for us? Why should you, the listener, care right now?
Because this law is not just bureaucratic red tape. It is a mechanism to ensure safety in a digital economy. As we move more of our lives online, banking, health, socializing, we naturally become more vulnerable. This law is the structural support that makes that digital life sustainable.
It is the guardrails on the highway.
That is a perfect analogy. Without it, the free flow of information the law talks about would just be absolute chaos. It would be the Wild West. This law brings order and accountability to the system.
Here's a thought I want to leave everyone with today. We talked earlier about the right to object. It is legally there. It is in the books. But how often do we actually use it?
That is the big question, isn't it?
Right. We have the legal power to say no, to challenge how our data is processed, but do we exercise it? Or do we just click accept out of pure habit because we just want to get to the next screen?
Convenience almost always wins over privacy. We are all guilty of it. But laws like this remind us that we have a choice. We don't have to be passive participants.
It is definitely something to think about the next time that little pop-up appears on your phone. Maybe pause for just a second. Read the first paragraph.
Indeed, be an active participant in your own privacy.
All right, that is a wrap for today's deep dive into the Philippine Data Privacy Act.
A truly vital topic for anyone living or doing business in the region.
Absolutely. If you learned something new today, maybe it inspired you to go check your own privacy settings. Make sure you follow the channel. And hey, for more educational cybersecurity content like this, you have to check out WeCyberYou.com.
Yes, definitely visit WeCyberYou.com. There is a lot of great material there to help you stay safe online.
Pronounced WeCyberYou, just like it is spelled. Thanks for listening, everyone. Stay safe, stay private, and we will catch you in the next deep dive.
Goodbye, everyone.